Good afternoon, everyone. It is a pleasure to be starting up the PCJ Speaker Series again after almost one whole semester off. In the prior 2 years, our theme was reimagining public safety, and over 28 events, we invited community activists, practitioners, policymakers, and researchers to join us to share their vision for achieving safer, thriving communities. This academic year, our theme is the myth of public safety, or the misrepresentations about what types of interventions help to keep us safe from harm, make people accountable, or allow for individual and collective healing. Our guests will identify the myths that dominate current discourse and shape policy, and in the process, set us straight, not only about how our systems can do less harm, but also perhaps how they can generate good for all communities, especially those that have traditionally been targeted for punitive criminal legal system interventions. This semester, our discussion will focus on dispelling myths related to the pretrial stage of criminal case processing. Toward that end, we are developing a program of 6 events and invite you to join us for each. You're here today, and I hope that you will continue to join us. We have summaries on the website for the ones that have already been set. And over the course of the next week or so, we should be filling out our website with the other 4 events. So please do visit the website to get details on those. Joining me this year and from now on is Katie Naples-Mitchell, PCJ's new program director. I'm excited to have her join the team. Katie is, if you will let me say so, my partner in crime. She has not only partnered with me in organizing these events, she's also taking over the moderating role, which I'm excited to pass along. Not only so that I can sit back and listen to the conversation, but also to hear the brilliance that comes out of her mouth over the course of the next set of events that we have. So please do welcome Katie, not just to the PCJ, but to this venue, and looking forward to hearing what your thoughts are once these conversations are done. Katie, I'm going to pass it over to you.
Terrific. Thank you so much, Sandra. I'm really grateful and excited to be joining the PCJ and to be able to host conversations like this together. And for today, we're going to start off our series about the myths of public safety in the pretrial context with 2 phenomenal speakers, Megan Guevara and Tennille Patterson from the Pretrial Justice Institute. PJI has been a leader in pretrial reform and pretrial systems change, working in particular with institutional actors over the last many years, and has shifted its focus in recent years to bring in more community-driven and community-responsive work. And we invite Tennille and Megan here in that spirit to talk to us about their campaign and the report that they issued last fall, the What If report. Their bios are available on the link that I dropped in the chat if folks would like to read more about their expertise. But we're going to skip the formalities of bios today and let them dive into the substance. But welcome, Tennille and Megan, and thank you so much for joining us.
Thank you, Katie. We're really, really excited to be here and to be a part of this conversation. Thank you.
So to get us going, we have a couple of kind of expositional prompts, and then Tennille and Megan are going to dive into the substance of this report. And then also, I just want to set some norms for our all being here together collectively today. As you all can see, this is a regular Zoom meeting. It's not a webinar, so we can see you and you can see us. So we're asking if folks are not actively talking, please keep your microphone muted so that we can keep background noise down, but feel free at any time to ask questions in the chat. And we will try to go through those questions and in fact call on people to ask their own questions once we break for that point of the program. I also want to note that at the end of the program, we're going to offer people to raise hands using the Zoom function, or if you'd like to physically raise your hand, you're welcome to do that too if you're on camera, so that we can take questions that way as well, if that's easier than the chat. If you happen to be calling in by phone, I know you won't be able to see the chat, but we will try to preserve it for posterity. And this program is being recorded so that everybody knows, and will be posted on our YouTube page at the end. I think that is all the housekeeping that we need to do. And so to that end, I'd like to start by asking what prompted PJI's What If campaign?
Thanks so much, Katie. I'm going to kick us off with a little bit of history and kind of some of the background about how we got to where we are today. And then Tennille is going to jump in with some more details about what if and where we're going. So PJI was founded in 1977. We've been around for 45 years now. And originally we were founded, we've always been dedicated to pretrial justice in the front end of the system, but we were really focused on how to reduce unnecessary detention and focusing on ending mass incarceration through limited jail detention. And we did that at the time by promoting the growth of pretrial services agencies with the logic that, well, if we're supervising folks in the community, then that's better than someone being incarcerated. So figuring out what do we need to do to try to keep folks at home as much as possible. And as you mentioned, at that time, we were working almost exclusively with folks in positional authority situations inside of government systems. And we were also a historically white-led organization. We were positioned as experts in our field, and we came in, we gave our advice, we worked with places for a time, and then we left. And for the first several decades of that work, we were really narrowly focused on the types of work that we were doing and the people that we were doing that work with. Then about a decade or so ago, the years are going by, a little more than a decade now, we started expanding our focus more broadly and looking at the pretrial system, starting from point of contact with law enforcement through the disposition of a case, recognizing that there are a lot of different decisions that go into pretrial outcomes for people and communities, and also many people who are involved in making those decisions. And if we don't look at that system collectively, then we're not going to get to the point where we can really make change and have an impact on the safety and well-being of communities. And at that point, our main focus was on ending cash bail, recognizing that cash bail doesn't work, and it has a very disproportionate impact on communities of color and people who don't have the economic resources to be able to pay cash bail. And knowing that on any given day, there are tens of thousands of people sitting in our nation's jails simply because they can't pay a cash bond. And so we started working with partners nationwide on what is it going to take to be able to end the use of cash bail. And we're really excited that that is now a movement that has been taken up by so many different organizations throughout the country, and that a lot of states are starting to change their policies in moving towards ending cash bail. But we also realized that there were a lot of unintended consequences of those decisions. And PJI was one of the voices that said, well, we can stop using money-based systems, and as an alternative, we can move towards risk-based systems. We've got the option of these risk assessment tools that we can use to be able to attempt to predict whether someone is likely to fail to appear for court and whether someone's likely to commit a new crime when they are out on pretrial release. And by providing that information to the courts, we're then able to make it more comfortable to release someone to the community as opposed to detain them pre-trial. That seemed like a nice, easy solution. But what we weren't thinking about was the fact that there's no way for us to assess risk without building in some of the racial bias that is at all stages of our criminal legal system, and the fact that people of color are more likely to be arrested, ergo more likely to have a criminal charge, a criminal history, and to score high risk on a risk assessment tool. And that to date, even though there have been many efforts to attempt to remove racial bias from those risk assessment tools, because of the data that they're built on, it's simply not possible at this point in time. And we also weren't thinking about the fact that we were reducing members of communities to numbers, and we were marginalizing people who were impacted by the criminal legal system even more through the use of those tools. And PJI as an organization, I'll also say myself personally, had been aware of the problem of racial and ethnic disparities for a long time. And we had been trying to figure out, how can we research our way out of this? How can we data our way out of the problem of disparities in the system? And that wasn't working. And for decades, that hasn't been working. So we as an organization realized that we needed to make a change, and we needed to change the types of conversations that we were having about what it means to keep communities safe. We had to go back to basic constitutional principles that we should be defaulting to release, and you should have to make the case to detain someone rather than the other way around in our criminal legal system. And we have to figure out what it really means to center equity. And so that is how we got to the point a couple of years ago where we said we really need to step back and think about what equity means to us organizationally. And then how does that impact some of the bigger questions of what does it mean to end mass incarceration and mass surveillance in the United States? And what is PJI's role in that broader movement, recognizing that it really is a movement beginning with the grassroots and with impacted communities. And I'll turn it over to Tennille to talk about where we've gotten since we had that realization.
Yeah, so I'm just going to talk a little bit about, the mechanism by which the realization, came to fruition. We knew that in order to begin to have these conversations with folks in the community and folks beyond ourselves, we had to first begin to have those conversations internal to the organization, which is often a very challenging proposition. There are so many things to consider, so many moving parts, whether in leadership or folks doing programmatic work that says, how do we begin to address racial equity internally, right? So we knew that we could not espouse values of racial equity, values of community engagement, values of not coming in as experts, but as listeners, acknowledging that the expertise is in the community, that we couldn't begin to espouse those values and to demonstrate them until we really began to wrestle with what racial equity meant for us as individuals within an organization. So essentially, before we could, do the talk, we kind of had to walk through that ourselves. We really had to experience it. And so we invested time, financial and human resources, and a lot of focus on what does it mean to go from a white-led organization that was very comfortable with evidence-based practices and frameworks and decision-making matrices and tools, and quantitative data. All good things, right? All things that are necessary in this space. But what does it mean to go from valuing and lifting those things up as almost like the only things that matter to an organization that centered equity? And how does centering equity change the questions you ask, change with whom you have conversations, change when the conversations happen, change the shape of the table by which you have those conversations? And to do that, we actually sought support from clinical social workers who really helped us unpack our own embedded, not just implicit bias, but also the impact of systemic racism on the way we think and the way we behave and the way we operate our organization. And then we also I sought support from organizational consultants that helped us to really think about, all right, now that we've started to shift into personally, now how does this reflect in our work, right? And so this was and is an ongoing project. We're in our third year of our racial equity journey, and we've seen a ton of shifts. And Megan and I have had the privilege to enact a ton of shifts relating to these realizations and to these new learnings. So not just in terms of how our organization is structured, Megan and I's co-leadership is a direct function of the equity, or output rather, of the equity journey. But everything from our policies and practices to our staffing, to just even how we manage performance appraisals have been impacted by our racial equity journey. And then, of course, what we're doing on the outside has been impacted. And so we're going to talk a lot later on about values and the importance of centering values. But there's this notion that what you value is what you invest in, right? And so we began to ask ourselves the question of where did our investment lie, right? We were proponents of ending cash bail, but we were also proponents of another type of option, what we consider to be one of two only options. And in terms of how do we get comfortable, as Megan mentioned, with release and the presumption of innocence. But the reality of it is that there are more than two options. And sometimes what systems do as a state of injustice is limit your imagination and limit your freedom of thought. And so as we were trying to break through that, we said, well, what are the other possibilities? And as Megan mentioned, many possibilities exist in our constitutional principles. The presumption of innocence, the values of liberty, the values of equity are available to us to utilize. And we acknowledge that those aren't the things that are necessarily in practice, but that doesn't mean that we can't begin to raise those as issues and remind folks that they are at our hands, if you will. And so internally, we rethought our theory of change. We centered community as an accountability partner, even though we're working primarily with system actors. We acknowledge that shift, that we are accountable to the people that are impacted by the decisions the system are making. Our decisions and our theory of change is now values driven. And so what does it mean to have equity, liberty, innocence, accountability at the center? And then we did not, even though when we changed our position, we were accused of such, we didn't abandon data. We continue to use it as a part of how we examine how do you employ equitable pretrial policies and practices. But we look at the data to also understand, what actually works about risk assessment? What doesn't work? What are the focal points? Are we focusing on failure? Are we focusing on success? And then what comes as a result of the policies and practices that we implement? Extensive incarceration, an expansion of surveillance, an expansion of the carceral system in nature? Are we substituting incarceration in the jail with incarceration at home, or supervision and surveillance and onerous conditions that are replicas of incarceration? And then does that align with our constitutional principles again? And so going back to this notion of thinking big and rejecting this notion that there are only two options, we stepped back and we said that we can lean on the presumption of innocence, and we can lean on the values of liberty, equity, and freedom, and that we have a lot to work with when we start there.
Phenomenal. Thank you both for that overview of PJI's evolution and of your internal and iterative process of inquiry. And I think that's a perfect transition into this external process of inquiry, right, which is teed up by this What If campaign. So can you tell us a little bit more about how you all came to the What If campaign, what gaps it's filling in our discussions, and how you arrived at this list of kind of 10 core ideas as jumping off points for reform movements?
Sure, and we have a couple of slides to share here. So as we mentioned, a lot of this came out of the journey that we've been on thus far. And really there was a particular flashpoint around this binary of risk assessment for cash-based systems versus risk-based systems. And we wanted to step back from that, knowing that pretrial is many decision points and the result of a lot of different culture within the criminal legal system as well as within the community, and starts from the first point of contact when someone could potentially be arrested or when there's opportunities to avoid an arrest. So we wanted to say, what if we thought big? And what if we really did put equity at the center? How would that change the entire system? And really for us, this is still very much an evolving hypothesis. We don't want to put this out as, this is the solution to pretrial justice, but this is really about a series of questions that we want to engage communities in. And knowing that the answer is going to be a little bit different depending on where you live, depending on the population of your community, the challenges that you face, the resources that are within your community, and really seeing this as something that we want the opportunity to be able to go out into different communities in the country and have conversations about and test. But as Tennille mentioned, central to this is really rejecting the binary that the two choices that we have are either using money as a way to potentially detain people or as a way to, as they say, have someone have skin in the game if they're released, or the use of a risk assessment tool. We know that there's racial bias in both of those options, and we don't have to accept that those are the only two options that are available to us. And very often we see the conclusion to a discussion about the challenges of risk assessment tools being, well, it's better than what we were doing before, or it's better than just using gut instinct, and accepting that as the potential solution. We want to figure out what is option C. And so the what if conversation is really about what does that option C look like in different communities.
I think
and we can
gotta
make
go back one more. Maybe.
Oh, sorry about that. And I was going to say we can also make these slides available, Brian and Katie, to be able to share with the recording if you'd like.
Yeah, and just to go back to Katie, your question, we really focused on in the next series of questions, we really focused on bigger questions, and we focused on what we wanted to build rather than what we wanted to tear down. And so we really also wanted to avoid this notion of trading one system of incarceration for the other. And so as we go through the slides, you all will see we can make the slides as well as the what if document available as well, which each document has commentary that is also connected to where we also show community responses to some of these questions, because as we often experience, that the community has wrestled with these questions far longer than we've been poised to ask them. And so going back to the notion of ending mass incarceration and advancing equity, again, it's about what values are we espousing. We believe that the conversation starts there. So our new theory of change really starts with having a conversation with folks at the table that say, based on the outcomes of your system, what values are being reflected? And so we know that if values are not explicit, then they're not going to show up in your budgets. They're not going to show up in your allocation of resources. They're not going to show up in your programmatic interventions. And we know that if you don't center equity, even really good policies and practices are going to have disparate benefits and disparate outcomes. As I like to say, racism is a sludge at the bottom. And if we don't center equity as a filter, as a lens by which we employ practices, we will still see, and we still have seen, who gets access to these new interventions is often impacted by systemic racism and injustice. And the other thing that we know is that culture overrides your policy and practices. And so when we talk to folks about equity, we talk about it, how is it reflected in your culture? And so again, liberty, equity, the presumption of innocence, what does the system look like if those are the things that are centered?
So then we started to really dive into the different decision points throughout the pretrial process. And though a lot of what's in What If is related to local practice, this really stepped up to the level of state policy as well as local decisions, knowing that we arrest people for a lot more things now than we did 20 years ago, 50 years ago. And there's a lot of activities that are really related to basic human needs that we arrest people for, and we use the criminal justice system as the solution or attempt to use the criminal legal system as a solution for what often are public health problems or social service problems. So if we think about issues related to mental health, to substance use, to housing instability, what is the solution that we really need as a community to those problems? And the criminal legal system isn't it. So we have the opportunity both to look at what is in our criminal code, as well as what we choose to arrest people for and what we choose to prosecute people for. And if we examine those questions within our communities, and if we just stop bringing people into the criminal legal systems for issues related to these crimes, then we would have a lot fewer people that are potentially eligible for pretrial incarceration, pretrial supervision, and it's a way to be able to shut the front door of mass incarceration, since really this is the first step in determining whether somebody goes on to a jail sentence or a prison sentence later on. We also know that misdemeanor arrests are a very large proportion of jail populations across the country, and that those arrests extract wealth from communities of color through both cash bail as well as fines and fees and other fees for different types of pretrial release, like electronic monitoring. So if we really look at, are these crimes that are really making our community unsafe? Or are we making our community less safe by arresting people for these crimes, destabilizing them through removing them from the community and from their families, and then folks having to pick up the pieces as a result of that wealth extraction or that incarceration later on? And there's a lot of research that tells us that the way we're doing things now is actually destabilizing our communities instead of making them safer. So revisiting what we're arresting people for, what is available for criminal charges, as well as looking at if we took all those resources that we now invest in the misdemeanor system and in dealing with crisis inside of jails, and instead invested that in other types of community alternatives to stabilize and support people, what would that look like?
And then directly in line with the series about public safety, we asked the question of safety being a broader consideration. And we challenged ourselves around who are we speaking about when we talk about safety? We know from our hierarchy of needs that safety is a fundamental need for every single human. You cannot get to survival, you cannot get to thriving without having that need of safety fulfilled. But when we talk about safety, we typically aren't talking about people who are system impacted. And even when we talk about community, we often are talking about very specific communities. Almost as if the communities that are significantly impacted by the justice system don't have a craving and a desire and a right to be safe, as if they are a product of their own environment, if you will. And so what happens when you begin to ask those questions and you broaden your perception of safety? We know that very few people commit violent crimes when released, but every single person that comes into contact with the jail system is exposed to tons of risks. And that potential loss is significant. Everything from just overall destabilization, loss of housing, loss of employment, loss of access to your children, and even loss of life. Overdoses in jail happen within the first couple days. There is an opportunity to be subjected to violence in jail. And again, we're talking about individuals who are charged, but not yet convicted. And so these are still innocent folks who are exposed to all of the risks that come with being incarcerated in a pretrial state. And so going back to our values, so what does it mean to maximize safety for everybody? Members of the community, victims of crime, as well as the individuals facing charges. And so when we begin to ask that question and we lift up safety as a value that is applicable to everybody, then we begin to design and think through policies and practices that look different than our current ones in place.
Then we started to dive a little bit more into law enforcement practices and opportunities for deflection from arrest, knowing that if we don't have contact with law enforcement, then that helps the dominoes to fall in terms of keeping people out of the system further down the line. And fortunately, this has become a very popular question in a lot of communities. What if we had options other than 911 for people in crisis? And we know that 911 is the default when there's a need in communities, when there's no place else to call. And so fortunately now we have options like the National 988 system for folks who are dealing with mental health crisis, and also a lot of communities that are putting civilian responder systems into place where we're seeing a lot of really fantastic results, knowing that often folks just need some sort of stabilizing resource to be able to help them through a crisis, or they're dealing with a root cause problem like being unhoused, a substance use disorder, or an underlying mental health issue that cycling through the criminal legal system is exacerbating rather than helping. But because 911 is the hammer that we've had for so many decades, everything has been a nail in terms of response. So expanding the alternatives to 911 that are available in communities, and most importantly, making sure that the types of programs that those alternative responders would refer somebody to are well-resourced and available, can make a huge difference in stemming the flow of folks that are coming into the criminal legal system as the result of contact with law enforcement, and of course, avoiding the potential for violence and death that comes especially to communities of color with contact with law enforcement. And then for folks that do have contact with law enforcement where there is the potential for an arrest, expanding the use of citations and summonses for many charges. This is a highly underutilized approach, but again, something that has been very successful in places where it's been undertaken. But a clear language citation that lets someone know that they are potentially facing a charge, that they need to come back to court on a certain date, that this is where their court date is, and this is how to get more information, can allow someone to stay in the community without unnecessary surveillance and without a period of pretrial incarceration. It avoids the question around risk assessment tools because no one is in a position where their risk would need to be assessed. And this still allows someone to be held accountable for their behavior if necessary, but it doesn't take their constitutional rights and toss them out the window through an extensive period of pretrial incarceration. We know that for citations to be successful, that they need to be in plain, clear language, and they need to be accompanied by a court reminder so that someone knows what they're responsible for doing. And we also know that this is another area where there is the potential for racial bias, where there is a lot of discretion on the part of law enforcement about how those citations and summonses are used, and that it can be very difficult to track data about potential bias in how these decisions are being made in the field. So it's important that there is very clear guidance for law enforcement about when to use citations and summonses, and that we're tracking who's being cited and who's coming into jail to make sure that this is not another area where there's unintended consequences. But the combination of deflection and the use of citation has the potential to really significantly stem the use of jail for folks who are still constitutionally innocent of what they're being charged with.
And the next two questions, and even the previous one, is where we really began to look at what are our constitutional principles, and then how does that value of accountability become a two-sided street, if you will. And so if you value accountability, is it just accountability for the folks that are facing charges to the system, or is there also an accountability from the system to the community? And so here in this question about judicial officers releasing everyone who's not statutorily eligible for detention. And so I like to say that there's a lot of statutory cover provided by way of the Constitution and the Supreme Court for the presumption of innocence and presumption of liberty. Most state laws have very specific guidance about who is and who isn't eligible for preventive detention. But we don't see that actually happening in practice. Oftentimes, both money as a condition of release creates significant opportunity for preventive detention, and risk assessment, which often puts people, which doesn't include a detain or release, or shouldn't be used for a detain or release decision, but often because of the risk assigned, either results in a high bond which again, the individual is unable to post and therefore subject to preventive detention. But then we get into arguments about dangerousness that still result in detention. And so we know if no one was detained who didn't meet the legal threshold, then the jails would begin to empty. And as Megan mentioned, then resources would be freed up to really focus on justice for individuals that are remaining and have to be system impacted. And then the other question that we asked about judicial officers was, what if they only considered the risk of fleeing prosecution and committing a violent offense when deciding when someone should be detained? And this also goes back to this notion of safety and whose safety are we in consideration of? And then how have we kind of bastardized this notion of flight, right? And how have we conflated failure to appear with fleeing prosecution? And we'll talk a little bit later about what happens if we consider a failure to appear as a function of societal impacts and not a desire to conceal yourself or avoid your day in court. And oftentimes the conditions of release or the decisions to detain are really considering flight and not merely a failure to appear. And then if judicial officers are only considering the risk of committing a violent offense when deciding when someone should be detained, it increases the burden, right? Whereas now we see that any new crime is often the reason for individuals to be detained. And so it gets us back into that question of when we're talking about safety. Are all crimes threats to public safety? Or is our criminal code voluminous? And so you could be doing a number of things that are no threats to public safety at all, but they provide the opportunity for you to be incarcerated pre-trial. And so this quote here by Thurgood Marshall, if folks haven't had an opportunity, I think it really lends itself to the complexity of a justice system, but the reality that we still have to lean upon our constitutional principles. And so there is always going to be risk when we're talking about a system relating to criminal activity or potential criminal activity. But we still have to uphold the principle that we must honor the presumption of innocence.
And I'll also add here that this is one of the concerns with risk assessment tools as well, that even though the constitutional principle is related to avoiding flight and keeping people in the community safe, what risk assessment tools often measure is the likelihood that somebody will fail to appear in court. So whether they'll miss an appointment, and then whether there's a likelihood that any new crime would be committed or that somebody would be arrested for any type of new charge. And so it does not meet the threshold of what we're really concerned about when we consider pretrial release.
I'd just like to add one little additional variation on top of that, which is some jurisdictions like here in Massachusetts, the risk of flight or of non-appearance in court is part of one set of bail laws, and you're only allowed to consider the potential risk to public safety on a more circumscribed set of offenses, right? This is also the way that federal detention was originally built, and there are other jurisdictions that do that. So that risk assessment tools might be totally in opposite to the actual inquiry that judges are required to make at a first appearance, right? Because the legal regime might have that kind of bifurcated system where for certain kinds of harms or certain kinds of offensive that have been criminalized where there may not even be any kind of interpersonal harm, right? There is a more limited inquiry that judges are supposed to make. I just wanted to add that layer of nuance.
Absolutely. Thank you, Katie. And then for those individuals that are going to be released, we wanted to ask the question, what if judicial officers only set conditions that were directly related to an individual's circumstance? So over time, the number of what are called standard conditions in most places has grown. And again, this is about comfort in terms of releasing an individual. And we have replaced mass incarceration with mass supervision in a lot of places. Many people who are on supervision with an extensive list of conditions that then can result in their incarceration if they are not compliant. But we don't ask ourselves the question of, are these conditions actually effective in increasing the likelihood that someone is going to return to court safely? And do they meet the constitutional standard of least restrictive conditions necessary? And there's really very little data on the effectiveness of many of the conditions that people who are on pretrial release are subject to, other than court reminders. We know that court reminders are very effective, but the information on conditions like electronic monitoring and pretrial supervision is mixed at best. And we have to ask ourselves the question, is it fair to be restricting people's liberty in this way and restricting their constitutional right to liberty in order to subject them to a condition that we're not sure is actually making a difference in the likelihood that they will return to court safely? And also, individuals have the constitutional right to individualized conditions, that their particular conditions of release are related to their particular likelihood of returning to court and also the charges that they're facing. So we need to be asking more questions about, are we giving folks a laundry list of conditions because it gives a sense of security, even if it's a false sense of security, that person is going to be safer in the community? And then are we disrupting people's lives and destabilizing our communities through the use of all of these different conditions? So for communities, if they were to sit down and look at, what are you trying to achieve? Again, like Tennille mentioned, what are the values that you're trying to uphold with your pretrial justice process? And are the conditions that you're subjecting people to actually helping you to uphold those values? And are those conditions meeting constitutional standards? We think that in a lot of cases that will not be true. And we really need to cut back on what we're subjecting people to in the community, and thinking about, if our default really was release and freedom, then what would that look like and how would that change the conditions that courts are using? There we go. And along those lines, what if conditions were only available if they're proven effective in increasing a person's likelihood of returning to court safely? And again, this is not necessarily returning to court and not missing an appointment. This is reducing the likelihood of flight from prosecution. But we're also seeing an increased focus on individuals getting support for making those court appointments and being able to get back, and we'll talk about that as well. But when we think about, what are people beholden to the court for? What are they legally obligated to do, and what could they potentially be in violation of a court order if they don't do? If we limit that list to things that have been proven likely to increase someone's returning to court safely, what would that list be?
Yeah, I wanted to say something else about this interesting mix we do in terms of how we treat people who are system impacted. And so oftentimes, even if we have an evidence-based tool or a tool that uses data, like a risk assessment, that we feel really, really good about, we don't feel really, really good about it, but the folks that are users feel, again, it's better than gut, and it's better than money. And we say that we have the data that's validated and can be extrapolated to the population about, what do people who behave this way, live in this place, do as it relates to appearing for court and or committing a new crime. But then the conditions that we subject them to are not based on any evidence whatsoever. And so it's almost as if you go into a doctor's office and he does a blood test and he gets your results and he says, oh my goodness, you have this rare genetic disorder that causes your blood to clot. And then he says, but come see me once a month, eat 2 squash every day, and drink some water. is that actually going to impact me in a positive way? Or does that just make you feel more comfortable and you believe you've done something? But I think it goes back to this notion that we're okay with these off the cuff decisions when we're talking about people who are impacted by the system, when there's no data that suggests that asking a person to do drug testing and asking a person to have limited mobility by way of electronic monitoring and asking a person to go seek care involuntarily actually are going to create a successful return to court and prevent them from committing any crime while out. So I just wanted to toss that in there, because it's often we make those mental jumps, but sometimes you have to pause and go back and say, does this actually make sense, and what I want to be subject to this rate of decision making? And so going back to our questions, so what if community supports were available to help ensure return to court, right? So what if we believe that people really did want to come back and just needed access to supportive services? And what if those supportive services were outside of the system? I think that's really, really important, understanding that we want to limit the reach and depth of the system and have the system focus on the things that are really important, and that we have a bevy of community organizations that are poised to support folks to get to court and poised to help people with access to resources. Now, they absolutely need more money to do so, and the funding has to be commensurate with the level of work. But we know that most barriers being connected to housing, transportation, lack of childcare. The court is an hour away from where I live. All of those things. And that's why individuals fail, not necessarily because they are flight risks or attempting to conceal themselves. And so if we believe this, then how do we create and open up opportunities for community supports to support folks? And so we know that this pretrial process, the system can either be a point of intervention and positive connection, or it can be a complete disruption to a person's life. And we of course want the system to be a point of intervention to help people get access to resources that they need.
And all of the interventions that we're talking about were well-intentioned when they were put in place. And there was a goal to be able to improve the safety of the community. Many conditions of release are related to attempting to support people while they're on pretrial release. And they've resulted in a lot of unintended consequences because there was not that equity focus at the beginning. And so by stepping back now and engaging in community conversations, a lot of us, myself included, PJI organizationally included, have had to acknowledge that even though we were attempting to do good things and we thought that we were moving the system in the right direction, we thought that we were taking steps that would support the community, because of the limited focus of our experience and because of the lack of the perspectives of impacted people and community members at the table, we were having those unintended consequences. And so now we're needing to step back and say, what does it look like to have these conversations within a community, and thinking about who needs to be at the table, what values are guiding this decision making, who's coming into contact with those pretrial decision makers, and what options are available, and what are the options that need to be available in your community. And recognizing that we also can't just create a new list that can be carved in stone and say, well, these are the options that are necessary as alternatives to 911. These are the supportive services that every community should have. All of that is going to vary depending on particular circumstances, and the need of a rural community that has a lot of folks who are affiliated with an indigenous tribe is not going to be the same as the needs of a urban community that has a very diverse population, places with different resources for mental health services, transportation, childcare, different states with different criminal codes. This is all going to look different. And we're having to step away from PJI's past as well, where we would have tried to come up with, one framework, one overall guiding document that would give the answers to all these questions, and recognize that we're not in a position to answer the questions. We are in a position to hopefully pose questions that are helpful, and then be a resource to communities as they figure out what does this look like for themselves. And we also need to recognize that there is a lack of trust with a lot of the elements of the criminal legal system for a very good reason. And so really engaging community and being able to have these conversations in an honest and authentic way takes a lot of time, and it takes a lot of rebuilding of trust in order for this to happen. So this is not an easy process. It is a complex process. And the other thread that's been common throughout all of these questions is that it goes beyond the criminal legal system. It involves the human services system, it involves the public health system, and it's really about bolstering a lot of the other institutions in our communities in a way that makes them better able to serve impacted populations. And all of those systems have histories of bias and histories of oppression as well that need to be dealt with. So we're talking about some very big, complex issues, but we've also realized that when we try to figure out one easy pat solution for a lot of these problems, that we end up just trading one system of oppression for another. And we'll be having the same conversation in another 5 or 10 years. So we hope that this is an opportunity to really be able to break some of that cycle of bias that's been in place really since the end of the Civil War, and going back hundreds of years before that, and be able to create something new. But we recognize that we're still very early in that creation process, as opposed to being at a point where we have a lot of answers.
All right, well, thank you both so much for that presentation. And I know you're covering a lot of ground. So in some ways that was like our 10,000-foot view walk through the document. And I know there are lots of rich resources that are linked there, and lots of allusions to other thinkers and organizers who have been doing some of this work already. And I know I was trying to populate some kind of live footnoting in the chat, so apologies if that was a distraction, but hopefully people can use this as a launch pad and a jumping off point for their own processes of inquiry, right? That's the whole goal. I certainly have some follow-up questions that I'm happy to start us off with, but I want to remind all of our participants here, there are some 70 of you logged on, that this is now going to be an interactive process, and we would love you to either raise hands or to drop questions in the chat so that we can dig deeper into the next phase of the conversation. But I will get us going with a follow-up question. And I think it leads pretty well off from where we just paused. And in particular, you've talked a lot about what it looks like now to change your model of operation, right? Instead of being this focus on institutional players at the table, now there's this real effort to involve members of directly impacted communities in decision-making. And so I'm wondering if you could be even a little more specific with a concrete example or something like that about what that's looked like in a real context. What does it mean to have community as an accountability partner, I think is how you framed it, Tennille. And how does that work in terms of producing events or reports or recommending policies? How is that enacted? How is power leveraged and shared? If you all could speak to that.
Megan, you're going to kick us off? I saw you nodding, so I just wasn't sure.
I can definitely do that. And so I think, and I appreciate you mentioning, Katie, that a lot of this is built off of efforts that have been made in local communities. And that's a big piece of this as well, of how do we shine the light on grassroots efforts that are happening in communities around the country that deserve to be given some time in the national spotlight, because there's so much we can learn from what's already been done. And I think in terms of community engagement, that's definitely the case. There are a lot of different models that are out there. Everyday Democracy is a resource that we have looked towards with a lot of great tools for how to do community engagement. But the way that we have approached this in our work is to figure out where we can partner with existing coalitions, knowing that there are grassroots coalitions around the country that are working on issues related to to avoiding new jail construction, to pretrial reform as well, and saying how can PJI be a resource to community groups that are already in place, rather than us attempting to create community coalitions, and really being able to work with those groups to say, what are your goals? What are you trying to accomplish in this work? And how can we help to translate those goals into operational realities, and being able to support the conversations with system folks. And for the system folks that we work with, encouraging them to engage with the coalitions that are out there, because in most places, if you look for them, those coalitions are there. And also making sure that community and impacted community are not necessarily the same thing. And they're two different types of voices and different types of perspectives that need to be at the table. But making sure that if we're going to raise community voices, that there's the opportunity for individuals and families who have been directly impacted by the system, who know the consequences of that experience, to be able to support setting the agenda. And in an ideal world, you're able to bring those community voices and system voices together from the outset of this work. Very often that's not the case because of those trust issues that we were just talking about. So very often at the beginning, it's creating parallel processes, so that there's a space for community to have their say, a space to understand what is happening in the current system, and then figuring out how do we weave those together. But if you look at examples like Los Angeles, that has built a infrastructure for community input into their criminal legal system reform processes, if you can do it in a city the size of LA, then hopefully that means you can do it in a lot of different places in the country. But I think that's a great example of a place that had to engage in years of work to get to the point where both the community was able to build the collective power to be able to have a voice at the table, and then to have a process where agreements were able to be reached between the community and the system. And now it's at the very difficult point of accountability of, okay, these agreements were reached, and then how do we create space for the community to hold the system accountable for actually implementing the changes that were agreed upon. And we also know that implementation phase is a lot of times when things fall apart. And that's a real focus for PJI as well, of what does it take to move what is a reform, which by definition is change, to actually become the way we do business in a system. And that takes a level of transparency and accountability that we frankly don't have a lot of good models for yet. And that's something else that we need to be working to create.
Thank you so much for that. Anything to add, Tennille, before we move on to the next set of questions?
Nope, I think Megan covered it.
Okay, great. Yeah, and I'd love to talk
Thank
more
you.
about that gap between kind of things at the level of policy and things at the level of practice. And so maybe we'll get there at some point. Next up, David Porter raised a hand. So go ahead, David, and ask your question.
Hi, my name is David Porter. I'm an assistant federal defender in Sacramento, and I very much enjoyed your presentation and and the work that your organization is doing. And just following up on the last question, I'm wondering about your opinion about the efforts of Larry Krasner, the Criminal Justice Reform District Attorney in Philadelphia. He's taken a lot of these steps that you're talking about in terms of eliminating cash bail, not prosecuting low-level crimes, and so forth. And I'm just wondering what your thoughts are on his efforts, and can those be used as a model for other places in the country?
So I'll jump in. So I'll put a disclaimer and say that my comments are not specific to his efforts, and more so the broader question around progressive prosecution and the role that it plays in ending mass incarceration. And I think that I think it's inherently complex, right? So prosecution as a function of the system is intended to to be the arm, essentially, to enact punishment. And so there's opportunities, but it's also a powerful place. And so it's ripe with opportunities to do things differently. What we've seen, and by we, I mean, I'm sure the majority of us on this call, is that it's a challenging place to be. You're fighting against crime narratives. You're fighting against what might be actual real increases in crime in your specific community that can't be ignored, that can't be relegated to statistics or how you read the data, that there are people impacted every day by violent crime increases in certain cities and jurisdictions. And so I think that for individuals that are committed to ending mass incarceration and actually protecting the safety of the public, that, again, I think it all goes back to values. Is the presumption of innocence a value that I espouse? Is equity and liberty and a value I espouse? And then what's within my actual political will and power to deploy? And I think even in those examples, just going back to Megan's comment about community engagement, there's still a real need to ask the community what they want. So even sometimes in those positions where you have such a bevy of power, sometimes the voice of the community still isn't present. And so are those new policies, are those decisions still influenced by the community? So what happens to a community when I no longer prosecute these crimes, right? Are there even unintended consequences there? Because I didn't ask them, what do they actually need? What is their community facing, right? And so they may seem like heroic or very applaudable efforts, but the community's voice is still necessary. And so I think to wrap this up with a bow, I will say that the gift of the system is that it is huge, and so that there are many opportunities to enact change. And I think that you have to really be clear about the values your office espouse, and then who are you accountable to? Because if you're ultimately still accountable to the system is designed to incarcerate. And so it's going to be easy to kind of default back into that place. And so if you want to end mass incarceration, you probably need to change, who you're accountable to.
And I'll just add to that, one of the things I appreciate about the current conversations about prosecution is rethinking, what defines successful prosecution, that for so many years was about, conviction rates, and what prosecutors, both elected and their staff, were being asked to do was antithetical to a lot of the constitutional principles when we talk about pretrial justice. So Larry Krasner, I shared the resource for fair and just prosecution. A lot of other folks around the country that are stepping into those spaces are really saying, what does it mean to be successful as a prosecutor? And are asking some of the same questions around what does it mean to keep the community safe that we've talked about today. So we appreciate that those conversations are happening, and then need to ask the question of what needs to go before a prosecutor in the first place, and then what is a successful disposition of a case look like when we think about safety from both sides. And an issue that we did not raise specifically in What If, I think one of the other questions that Sandra and Katie had posed was, what did we not include? And the question of prosecutorial diversion is also a part of this conversation as well. And that is an area where prosecutors often have discretion to be able to say, well, if you go and participate in this program, we will defer your charges, we'll potentially drop charges if you're successful. And those are another area that are well-intentioned efforts to try to move people out of the system that can introduce a lot of racial bias in terms of who those opportunities are offered to, as well as bias if there's a cost related to prosecutorial diversion programs. So that's an area where that doesn't get a lot of attention in terms of how prosecutors can change the way they approach the pretrial process. That does need some attention, as well as the question of, what charges get put forward. So before a prosecutor is deciding whether or not to ask for cash bail, does that person need to be prosecuted in the first place? And are we collecting data on racial disparities when those decisions are being made as well? So we need to make sure that we are asking these same critical questions of folks who are in that quote unquote progressive prosecutor realm that we're asking of all prosecutors of, when rates of prosecution go down, when amounts of cash bail go down, when the use of cash bail goes down, is that being done in a way that is equitable, or are we continuing to deepen disparities?
Thank you all for that. And thank you for that great question. There's a question that was put in the chat by Lloyd McDonald. Lloyd, I don't know if you would like to ask it yourself, or if not, I can certainly read it for you, but you're welcome to unmute and ask it yourself.
Well, I'll ask it. I'm just curious as to what role the interest of crime prevention has in the what if calculus, and is there any objective data yet as to what the impact on the incidence of crime would be from the adoption of your proposals?
Yes, there are some different data sets that we can point to that let us know about the relationship between bail reform generally and crime. We do know that even one night in jail increases the likelihood of somebody getting arrested for another crime in the future. So that's another way where our current approach actually is decreasing the likelihood that our communities are going to be safe in the future, because when we incarcerate people, because we are destabilizing their home and their families, because we are increasing the likelihood that they'll lose their job or lose their housing, they're actually more likely to commit a future crime than less. So when we're able to support people in the communities, we make our communities safer overall. And there has been a lot of conversation lately about the relationship between bail reform and violent crime, and frankly, a lot of inaccurate narratives. There's some really good data out of New Jersey, which has had bail reform in place for several years now, that showed that there was not a negative impact on their public safety rates as a result of their changes. So there's a lot more people out in the community, and those people are staying safe and successful when they are out in the community. And actually, I just attended a webinar this morning that was put on by the John Jay College that was related to new data from bail reform efforts in New York. And while they're still crunching the numbers in terms of conclusive outcomes about the relationship between bail reform and crime, what the preliminary data is showing is that bail reform does not, it keeps more people in the community, and it does not have a negative impact on community safety. So what the evidence that we have writ large tells us that if we're able to support people successfully in the community, then that's something that over the long term increases the likelihood that our communities are going to be safer, as opposed to the disruption of tough on crime or increased pretrial incarceration policies.
Yeah, and I just wanted to expand really quickly on the notion of crime prevention, and what that actually means in the context of the criminal justice system. It sounds like it sounds great, but ultimately, crime prevention requires deep investment in the community and getting people access to resources. The criminal justice system's response is pretty quick. And so I think when we start asking ourselves these larger questions is, are we ready, able, and willing? Can we stomach the notion that we might need investment over the long term, over decades, to get to a space where we can actually quantify crime prevention? It goes back to the trade-offs that we're willing to make as humans and as citizens of the United States, relating to what are the true causes of criminal activity, pushing aside, the criminal codes that are that criminalize activity that are just living, right? And we know that came post-Reconstruction, where just everyday behavior was being criminalized. So going to a park, sitting in a train was now criminal activity that could get you access to law enforcement and put you in a pretrial environment. So putting those things to the side, as a community, if we start asking ourselves, are we willing to take the long approach to crime prevention? What does that actually mean? And it means that there needs to be deep investment in people's lives and their ability to have sustainable living.
Thank you so much for that. So we have about 5 minutes left, and I'm seeing 2 more raised hands. So just in the interest of time, let's take both those questions back to back, and then you two can respond. And then if there are more that come in, we'll adjust. But go ahead, Sandra, and then Patricia.
Actually, I'll let Patricia go first, and then I'll give my question. And if Tennille and Megan have enough time to respond to my question, they can. Otherwise, we could take it offline.
Okay, I have a very quick one. I actually work here at the Kennedy School. I'm currently developing a project for Sandra Susan Smith on the Massachusetts Probation Service and their efforts to address racial disparities. And one of the aspects we look at are risk assessment tools. And they use ORAS, which is the Ohio Risk Assessment System. So I'm new to this and not an expert in this subject at all. But what I'm interested in is what does PGI advocate for in terms of how to engage with the system? Because here we have an agency that is well-intentioned, led by a reform-minded leader who's on his way out, but has been trying various things over the last few years, and still, they're constrained in what they can do. They're a piece of a much larger system that doesn't move quickly. And so I'm just wondering if there are ideas out there about how to collaborate with the systems or bring some kind of impact on their ability to start changing these flawed tools that they're still using. Thank you.
And so my question is about mass incarceration itself. So the point here has been to try to end mass incarceration, but I don't know that you shared with us, and I would love to hear and probably have a conversation over coffee or something. What does it mean to end mass incarceration? So for instance, San Francisco says, we've done it. Follow our path, then we will all be there. I'm skeptical about that, even as I realize that they have brought down the numbers of people who are being held in their jails. And so I've been thinking a lot about what it actually means to end incarceration above and beyond simply bringing down one's numbers. And I wonder if you've thought about that and what you'd like to share about how we should be how we should be thinking about what should the kind of threshold be around which you can say, yes, we have ended mass incarceration.
That would be a wonderful question for coffee. And I hear some of the same questions in both Patricia and Sandra's question around, okay, what are we trying to achieve? And then where do we start? What are the steps that we can take, knowing that we're not going to be able to wake up tomorrow morning and snap our fingers and mass incarceration? And then I think there's that, the snowball that we struggled with at PJI of like, well, is ending mass incarceration just meaning nobody is in a jail or a prison? Or how does mass supervision and surveillance fit into that? And really, what is the difference between getting rid of oppressive structures completely versus just stopping putting folks in a certain position in a certain building? And so that, I think, is where we start, Patricia, with our conversations with system folks, and the reason why we really see this as a values-centered effort, both with system folks and with community folks. Because the first question is, what are we trying to achieve? And what does safety mean in our community? What does justice mean in our community? And those are conversations that we very rarely have, because usually we do start from a numbers place of saying, okay, we've got 3,000 people who are in our jail right now and it's crowded and we need to get it down to 2,000 people, or we're about to build a new jail and do we make that for 500 people or do we make it for 750 people? And the answers to those questions really lie in what are you trying to achieve through this whole process. And if you sit down with folks in your community and you sit down with folks in your system and say, where is the common ground related to those values? Very often that common ground is there. And then it becomes the responsibility of the folks in the system to say, okay, what are the steps that we need to take to be able to start moving towards the achievement of those values? And the values give you a place to go back to when your reforms start to head off the rails. So when we ask the question of like, okay, well, our jail is crowded, is it sufficient to just get those numbers down? You know, if we get from 750 people to 500 people in the jail, do we get to pat ourselves on the back? But is our community safer after we've done that? Have we been equitable in the way those populations have been reduced? Because in most places it's not the case. Most places the disparities get worse. And are we defaulting to constitutional principles because we say that we value constitutional principles? So those are the places where we like to start in our conversations with systems, and then recognize that it's going to take a lot of steps to be able to get there. And so if the implementation of a 911 alternative program is the first step that a system is able to take because there's the agreement and the funding, that's great, as long as it's helping you to get towards the point of moving towards where your values say that you want to go. And it's going to be the case that there are going to be other areas that are more difficult and more sticky, and where certain elected officials aren't ready to go there yet, or where, you know, the realities of the fact that we're dealing with compromise come into play. But that's really where the community should get to make the decisions about what compromises are acceptable and what compromises aren't acceptable in that process. And having known Commissioner Dolan for a very long time, and I started doing my reform work in Massachusetts, and know that that is a place where there's a lot of well-intentioned folks, but where conversations about racial equity have also been very difficult over the course of decades. So being able to continue to push those conversations about like what are our values and what is equity, and making sure that there's community checks for the folks in the system that want to make those changes would be the way to start. And then being okay with the fact that that's going to need to happen in pieces, and that this is we're looking at the marathon rather than the sprint, and what those changes are going to be is going to be the reality of the situation.
And if I could just say one thing to respond to Sandra's question about ending mass incarceration. I think when we as individuals think about what the real end of mass incarceration is, I think we should ask ourselves the question, when I envision the future of myself or the future of my children, what systems do I want to be in place where the default is punishment related to a harm that has been committed? And we know that there are many systems that go beyond the criminal justice system, where punishment, a punitive measure, oppression is the default or is the most readily available option. And so to me, mass incarceration goes beyond criminal justice. It goes into other facets of our life where we can be reasonably assured that if something goes wrong, punishment is the answer. And so I think when we think about what does ending mass incarceration look like, we have to think there. We have to start at that kind of 30,000 foot level.
Thank you for that, Tennille. And I think that brings us precisely to something you said earlier in the conversation, which is about thinking about what we want to build, not just what we want to tear down, which I know comes from a deep abolitionist history of thinking about presence as much as absence. So thank you both so much for this really rich conversation. And thank you to all of you who joined us here this afternoon and evening. And I want to just note that we are going to make the slides available, and the video will all be posted to our YouTube page, and we'll also share out those resources in our newsletter so that all of this has a record that people can return to. And please come back next week if you'd like to keep this conversation about the myths of public safety in the pretrial space going. Our guest is Megan Stevenson, an academic whose research focuses on similar issues, and in particular trying to gauge that question of safety for home, I think most recently, that Tennille really brought up as a thread throughout. Thank you both so much.
Thank you for having us.
Thank you.